All right, well, let's get going. I don't know if anyone doesn't know me. My name is Jonathan Guess. I am the membership coordinator here at the KBA, and I'm also the liaison for the law students. So you guys probably get all of my emails. You're probably sick of hearing from me by now, but we thank you for being here. This is the second of our new series that we're doing for law students called What You Can Do With Your Law Degree, and tonight's focus is on trial practice and personal injury. So we are joined by three local attorneys here that we think can shed some light into the field. First, we have Jennifer Franklyn of Leitner, Williams, Dooley, and Napolitan. Oh, geez, I always mess that one up. Jennifer went to UT College of Law, and she was licensed in 2016. We also have Rameen Nasrollahi of Egerton, McAfee, Armistead, and Davis. Rameen also went to UT College of Law and was licensed in 2014. We also are joined by Matthew McClanahan. He also went to UT College of Law, so we're sweeping that here today. He was licensed in 2018. So thank you all for being here. Before we get going, any of the students listening in, please, anything that you have on your mind, questions, anything you're just worried about or you would like to have them speak to, if you want to put, you're feel free to butt in and ask your question if you are comfortable doing that just through audio, or if you would be more comfortable just putting it into the chat. Please do that, and we'll definitely work those questions in. So let's get going here. So I didn't really, the bios I gave for you all were kind of abrupt because I was going to kind of prompt you to speak about yourself and your background and how you got in. So I guess first we'll start with you, Jennifer. So all of you, let's quickly just give us a kind of a specific rundown on what you're working on now, kind of what you're more focused on within the practice of law and how you got to this point in your career.
Sure, yeah. So I am a WT alum, undergrad in law school. I'm currently at Leitner, Williams, Dooley, and Napolitan, where I'm an associate attorney. I do primarily insurance defense. So if you don't know what that means, that's where an insurance carrier will hire an attorney to defend one of their insureds. And so that's primarily things like premises liability defense, car wrecks, some construction defense, workers' comp, things like that. Prior to being at Leitner, I was at a small firm in Knoxville where I had a more mixed practice, both litigation and then some more transactional work, some wills and estates, things like that. And then prior to that, I was a clerk for the Tennessee Court of Appeals, Judge Armstrong in Memphis, Tennessee. I think Rameen and I are both alums of clerking for Judge Armstrong, so it's funny, small world. But that's pretty much how I ended up here.
All right. What about you, Rameen?
I'm currently an associate at Egerton McAfee. I'd say my practice is 100% litigation, mostly state court. I do a lot of estate litigation where people are contesting wills or think an estate's not being administrated properly. I also do a lot of construction litigation on both sides. I represent homeowners, primarily for plaintiffs that, their contractors overcharging them or things weren't built right, that sort of thing. I also defend contractors against those same type of claims. And then I've also gotten into copyright litigation in federal court. Particularly, we have one client in particular who is a software company, and we've represented them in multiple cases. So that's the bulk of my practice. I've been here almost 5 years. Before that, like Jennifer said, I clerked on the Court of Appeals for Judge Armstrong. And I haven't bounced around a lot. I clerked and then found out about this position, and I've been here since 2016, I guess. So.
All right. What about you, Matt?
Need to unmute myself first. Matt McClanahan. I have a general practice. We focus on a wide array of issues, but as it specifically relates to litigation, we're on the plaintiff side often when it comes to personal injury cases. We represent a number of landlords. We have 2 or 3 large mobile home parks that we do all their evictions for them. We represent the landlord in any kind of actions that they see. Also, from a litigation perspective, we have handled partition actions. We have a considerable amount of conservatorship work both opposing conservatorships and trying to get a conservatorship put in place. And we can talk more about some of that stuff later. But just a small firm, general practice that I opened with a friend of mine, Alex Winston, this past year. I got married and started a law firm during a global pandemic in 2020. I don't know if that was a good idea or not, but so far so good. Anyway, been very fortunate and glad to be on this illustrious panel. I'm glad to be talking to you all today.
All right, man. Absolutely. So I guess just kind of a simple question. We'll start with you again, Jennifer. Going into law school, did you have an idea of the areas of practice that you wanted to focus on going in and even during law school? And then how did that develop while you were there?
Yeah, early on, not at all. I thought maybe I was more interested in criminal law, my 1L year especially, or maybe more public interest work. But my interest developed, especially after my 2L summer. I clerked with a Georgia law firm that did primarily plaintiff side catastrophic and wrongful death cases. So definitely solidified in torts. And, they gave me some valuable experience in terms of assisting during depositions, going to motions hearings, seeing how motions practice worked. And once I saw that hands-on, more of what happens in civil litigation, I thought this is the way I wanted to go.
Awesome. What about you, Rameen?
I came into law school thinking I wanted to do something with environmental law. But after my first year in law school, I didn't really have a plan for the summer. And Judy Cornett, of all people, came to me and said, "Hey, do you want to clerk for a judge this summer?" And I said, "No, I don't have anything else going on." So yeah, sure. And ended up doing that for half a summer. And I thought it was great. I was an English major in undergrad, so that really kind of dovetailed into that. So I decided that's what I wanted to do right after I got out of law school. So for the rest of my law school career, I just kind of focused on everything I could to make myself attractive for a clerking position. And then while clerking on the Court of Appeals, you kind of see civil litigation after it's already happened. You kind of see the whole breadth of it, I guess, from start to finish, going through the appellate records. And so I had that experience of kind of getting to see it from the top down, not necessarily in it. And then I applied for the position I'm at now, and they hired me to litigate based on that. So that's kind of how that developed.
Great. What about you, Matt?
Whenever I first went to law school, I always wanted to have a certain sort of a general practice, and that's sort of what I'm doing now. I really enjoy estate planning. I like working with wills and trusts, and I get to do enough criminal to scratch that itch, but not do so much that it becomes a major focus of my practice. But I guess that's one thing. Whenever I started law school, I didn't think I was going to do any criminal, but as I went through law school and as I went out into private practice, I've enjoyed that aspect of it a lot more than what I thought I would whenever I first got started.
Great. Okay, so let's focus a little bit on trial practice for a minute. Jennifer, we'll start with you again. So how did you, is trial practice similar to what you expected going into it, and how does it differ, and what was the learning process like there?
Well, I think my learning process was a little bit different because, like Rameen, my first true exposure after law school, after taking the bar exam, was as an appellate clerk. So I was reading deposition and trial transcripts. I was reading the court's orders, and I was just seeing it more from those decisions after they had been made. And often I was thinking to myself, why did they do that? I think they should have done something else here, things like that. But now that I'm actually in practice, as an associate, a lot of our role is discovery. I do a lot of depositions. I do a lot of written discovery. And insofar trials go, we still do general sessions trials, but I haven't had the chance to have a jury trial. Hopefully I will at some point in my career. I'm sorry, both my cats just came in. So if you hear some noises, they may try to contribute to the conversation as well. The joys of working remotely, right? But most of my trial practice is focused on pre-trial matters. So also things that would lead up to motions practice, dispositive motions, that type of thing. I think when I was in law school, I didn't realize quite how important the discovery process is. And a lot of times, you'll do discovery and then you'll go to mediation, or you'll go to some type of informal settlement. And what comes out during discovery will dictate what that settlement's going to look like for your client.
Great. What about you, Rameen?
I'm going to echo a lot of what Jennifer said. When you hear the term trial practice, and for the students, I don't know how much your professors have told you this, but unless you're in certain sections of law, criminal being one, if you're in sessions court, if you're in small claims court, those you tend to be in front of a judge and get to actually present evidence. But most cases don't go to trial anymore. If you're on the Court of Appeals, you see things that either got dismissed on summary judgment, or summary judgment was granted, or went to trial. So that's all you see. But then when you get into practice, you find out that's the minority of cases are the ones that go to trial. And most things, either you have a dispositive motion or they end up settling. So I've been litigating for 4.5 years, and I've had all of one actual trial in circuit or chancery that we got a verdict on. It wasn't a jury trial, never been in front of a jury, never had the chance to pick one, just because that's kind of the nature of the practice. So if your goal is to be in front of a judge all the time and have a jury all the time and kind of have that just movie courtroom experience, I don't do criminal law, but I would imagine that's kind of where you need to go with that, because that's where it really still happens. It's not to say it can't happen in civil court, but it's, in my experience, very rare. So
Great. Anything to add to that, Matt?
I guess a little bit of a different experience. Whenever I graduated, I worked for a small firm in Knoxville, had a wonderful experience, had a great boss, and he sort of gave me a stack of files and said, all right, there you go. So my first experience in front of a judge was in Anderson County General Sessions Court, and it was a landlord-tenant matter. We represented the tenant. This kid had moved up from Florida, and his mother was funding the litigation, but basically he moved up from Florida to go to UT as an undergraduate. He moved into this very wealthy woman's detached garage, like above the garage. So he's a 20-year-old kid, and there's a housewife, and the husband's gone all the time and all this other stuff. And she wasn't charging him any rent, didn't really know him. And it was kind of sketchy on how they even met. He just said they met on an app, and I was like, and I, whenever you're interviewing him, I said, listen, I said, it doesn't matter. Like, I'm not your mom. I'm not going to judge you, but did you have some kind of romantic relationship with this woman? Because now she had locked all the doors, she had changed all the locks, and he couldn't get into his stuff, and he was homeless basically, and he was having to live in a hotel. So something happened where she turned off the power, turned off the water, changed all the locks, and now he's out in the cold. And he comes to us, and we sue. He said, no, nothing's going on. She's just crazy, blah, 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 all this stuff. I'm like, okay. So we go to trial, and she represents herself, and which is pro se litigants are a whole other story. But anyway, have a little General Sessions trial there. And in the course of the discussions, they did have an affair. Okay. So that was something that came out in graphic detail from some texts that were disclosed. Her husband, not only did I find out at the trial, but her husband also found out at the trial, who was also in attendance at the trial. And anyway, so we were able to, the judge kind of splits the baby. We don't get any damages necessarily, but he gets to go get all this stuff, and he leaves because he hadn't been paying rent and everything. And it's a fair decision, but the kid's got a key. Okay. So he's still got a key to the place. And he's like, I think I need to give this key back to them over there. And the husband and the wife were like in a corner talking. And I'm like, no, do not give them that key. Like, you are like the last person that needs to go over there right now. He's like, hey, here's a key to that detached garage where your wife and I used to hang. So anyway, so that was my first experience in the courtroom. And he told me, so you'll pardon he told me, what are you going to do? And I said, I'm going to leave. I'm going to get out of here. And you're welcome to come with me. I suggest you do the same thing. So, but anyways, it was interesting experience. I would concur with what they're saying. I mean, the jury trial is somewhat of a thing of the past, and that's a shame, but you end up trying a lot of your mediocre cases anymore, which is sort of ironic. If you have a very strong case and there's a clear evidence of liability, then oftentimes it's going to get settled, and you're going to go through that discovery process, which the other panelists alluded to, which is very important in trying to negotiate the best deal possible for your clients. But if the facts are a little cloudy, or maybe the law is not on your side, you'll end up having to try those cases because there's a question of what a fair settlement's going to be. So I guess that's something that the movies don't really portray. A lot of times you've got one person, it seems like they're in the right and there's no question about it, and David has to take on Goliath and that kind of thing. And a lot of times that's not the case. You're trying the cases that are a little bit harder to prove and more difficult.
We have a student submitted question here, so this is a good one. So we'll switch up and start with you this time, Rameen. So in pursuing a career that focuses heavily on litigation, are certain courses or experiences more beneficial in law school?
Believe it or not, civil procedure is incredibly important for that. It's kind of hard because that's a very basic thing, but it gets taught to you in a vacuum and you don't really get to see how it operates, because you can read the rules and see, okay, I have this much time to respond to a motion for summary judgment. And it's kind of an abstract thing because you're not under a deadline. You just need to know that the rule says that. But once you get into litigation, all of a sudden it's, okay, the rule, I need to get this sort of relief from the court. I need them to dismiss this case, or I need opposing counsel to respond to the discovery. I've sent them and they're not, and they won't answer my phone calls or my letters. How do I get the court to do something? And what's the proper way for me to ask for that or make that happen? And that's where the rules of civil procedure come in. And when I was at UT, I don't know if they're teaching federal or state now, but they taught federal when I was there. So if that's changed or not, it really doesn't matter. Just civil procedure is incredibly important. I was so focused on clerking, I didn't really take anything like trial practice, or there were a few other litigation related courses. That's not to say they're not worth taking. That just wasn't my focus, so I can't speak to them. But anything related to Civ Pro is going to be totally worth the time if you have any interest in litigating. So
great. Jennifer, anything to add?
Yeah, I would say evidence is incredibly important. You're going to have certain objections that come up. Even when you're responding to written discovery, you're going to be making evidentiary objections. I also took a class, I want to say it was called like advanced trial practice or pretrial civil litigation. That's what it was. And Rachel Hurt, who is an attorney here in Knoxville, was the attorney who was the adjunct professor who did the class. And she actually brought in this random person she knew to act as a fake witness for us to do deposition and to depose this fake witness. And then gave us these huge fact patterns for one of us to be the plaintiff, one of us to be the defendant, and had us go all the way through motions practice. And honestly, that case definitely is the closest thing to reflect what my practice is now. That class, it was a lot of work, but it was really a great experience. And I think at the time I didn't appreciate how much it was preparing me for my work now.
Rachel is quite a character.
Yes.
That was probably really interesting. Yeah. Matt, what about you? Anything to add to that?
I would echo everything that they said. If you are interested in a criminal practice, then make sure that you take both adjudicative and investigatory criminal procedure at whether you're UT or LMU or any other law school. And I think just taking the clinic, actually, if you can get into some sort of clinic or have some sort of experience where you can sit second chair or be on your feet. There's no replication for the real thing. So I would encourage you to do that.
That's an easy time for me to plug and hopefully maybe towards the end of the year we'll start having the veterans legal advice clinics, and we're always looking for students to volunteer for those. So yeah, just echoing that from Matt, that's a great idea. So okay, so another question submitted from a student here. Matt, we'll just stick with you.
Okay.
You can go first here. So during our summer externships, what is the best way to convince our superiors to allow us to take on more responsibility?
So that's a very good question. A lot of it's not necessarily constrained to the legal field, but just do a really good job. Just be very thorough, make yourself indispensable, make sure that whatever assignment they give you, just hit a home run. Also, be busy whenever something is not being directly assigned to you. My grandpa used to tell me, he's like, whenever you're working a summer job, if everything else is done, sweep the floors, dust, do whatever, just do something to show that you're invested in the firm and invested in what's going on. So I would just encourage you to just be very intentional with the assignments they give you, turn them around in the time frames that they give you, and make sure that you're not just scrolling through Facebook.
Great. Yeah. What about you, Rameen? Anything to add?
At a law firm, we do this with our summer. We have a summer program. So when students come in to work with us over the summer, we'll give them assignments. And I think the best thing to do if you want to work on more meaningful work other than, we need you to go through these records or that sort of thing, is try to, and you may have to ask whatever attorney's giving you the assignment, if they don't tell you what the case is about or why they're having you do that, ask the question, why are we doing this? What is this helping with? And then if you do a good enough job on whatever it is you're supposed to go through, then you can go back and say, I know this is for, a motion for summary judgment or a discovery motion or whatever. Now that I've done this, can I take a stab at writing the first draft of it? If you've done a good job and they like what you've done so far, then they may let you. They may not. It might be something that, they're up on a deadline, it needs to be done quickly, and you don't have the experience necessarily to just crank that out as well as it needs to be in that short amount of time. And that's okay. But the more you know about it and the more you know how it fits into the case, the better situated you are to maybe take the next step on whatever assignment that is.
Great. Yeah. What about you, Jennifer?
I don't know if I have much more of any more unique input than what they've already said. And the two firms I've worked at, neither of them really do summer clerks or any type of summer program. But in my 2L year, when I was a summer associate, I found that, to go off Matt's point, just doing a really good job, a really thorough job, putting in a lot of time, and demonstrating to the attorney, you're being thoughtful, and you're trying to do your best job. I think that's probably the best way.
Awesome. Okay, so we have another student question here. Jennifer, we'll stick with you. So when we have the opportunity to sit in on court proceedings, what are the most important things to watch for and take away?
That's a good question. I think both, not only in the arguments that the attorneys are making, but the way that the judge asks questions. And some judges will just let the attorney say their piece and then have them sit down and ask if there's anything else, and then give their order. But more judges, especially I've found around here in Knoxville, they'll interrupt the attorneys. They'll have their own questions ready to go. And then seeing how those attorneys, especially attorneys who are well practiced and they really seem to know the case, how they respond and how they pivot when they are interrupted, and when they do have their notes or whatever they're prepared to be in there, or their train of thought that's interrupted, how they respond, and then how they then move to another aspect of the case. Also, I think the best attorneys are willing to admit to a judge when they don't know an answer. And that's always good to see. It's, if you don't know about what the judge is asking, or the judge is asking about a case you haven't read, don't try to wing it. You got to fess up. But I think watching attorneys, especially who have been in court a lot, who are well prepared, there are some attorneys who show up to court and they're not maybe the best prepared, but thankfully I think in Knoxville we got a pretty good bar. Especially now with Zoom going on. I know I argued a dispositive motion a couple of months ago, I want to say in Ray County, and the judge had a student who was doing some type of externship program just on the Zoom call, obviously muted, their camera off and that type of stuff. But that may be an option for students to get more exposure since virtually everything's remote right now. And it means you don't actually have to go in a courtroom and try to figure out which day is the motion day and is there anything substantive set.
Yeah. What about Matt? What about you? Anything to add?
No, I think those are all excellent points. I would just say, kind of view it like those old training videos. Like there was like the guy that does everything right in the training video, then there's like the dude that doesn't do anything right at all. So, and Knoxville has a great bar and we have a great bench. I would just observe the attorneys and try to learn from the ones that you see. If you see someone that you think has achieved success or is making a persuasive argument before the court, try to model yourself after them. Are they prepared? Does their trial notebook look like they've spent time preparing it? Same thing with the judges. I think Chancellor Weaver he's on my Mount Rushmore of great judicial minds, and he asks good questions and he's very, very thoughtful in how he approaches those cases. So being able to go into a courtroom like with Chancellor Weaver, where you have someone who's really trying to get at the heart of the matter and advance the law, I think that's an invaluable experience.
Rameen, any advice?
I will echo all those comments. I will 100% agree with Chancellor Weaver being on the Mount Rushmore of judicial minds. And to kind of go back to my last point, if you're in front of a judge who is asking attorneys questions about the rules, and Chancellor Weaver is notorious for this, and it's a good thing, it's not a bad thing, but he'll say, well, counsel, I understand what you're telling me, but doesn't the rule say, whatever the rule says? And to Jennifer's point, some people will say, well, I don't know that it says that, Your Honor, but if that's what you're telling me, then they have to pivot. They have to change their argument. You have to be able to do that on your feet, because especially Chancellor Weaver, and there's plenty of other judges, they'll be able to recall the rules better than you might, and they'll know that you're not quite on point with what you're doing, and you've got to be able to adapt to that. And if you can see attorneys in the courtroom that are able to do that, then they might be some of the ones you might want to try to talk to afterward or shadow, get in touch with. And if we ever do get back into the courtrooms where the public can just come in, it is tough if you go in there cold, but one thing you can do is call the court clerk and just say, hey, I'm a student. I want to watch some motions. Do you have anything on the docket that would, if you want to see a motion for summary judgment or motion to dismiss or whatever it is you want to see, just call the court clerk and ask him what's on the docket. Chancellor Weaver's clerk probably be very happy to help with that, but you can get that information and take the initiative to just go into court on your own. So
That's great. Yeah. I'm going to go ahead and think of this now. I didn't think of it until the end of the program yesterday. If you all, Jennifer, Matt, and Rameen, if you wouldn't mind, if it's okay with you, just putting your emails into the chat. So if a student wants to jot it down and ask you any questions personally or anything like that moving forward, that would be great. Okay, so a couple more student questions were submitted. So Rameen, we'll just stick with you here. So for post-graduation employment consideration, does it matter where you had an internship or what field of law, or is it the experience itself that is the most important?
I don't know if I'm going to have a great answer to that, because I really did, after my first summer, I said, okay, I want a clerk. I'm going to put all my energy into that. So I'd interned for an appellate judge that first summer. And then the second summer, I really looked around and tried to find a judge that I can intern with. I ended up clerking for, when he was on the Court of Criminal Appeals at the time, but he's now Justice Bivens. So I had that experience my 2L summer, or between 2L and 3L, I guess. So I didn't work during school, but there were several classes that I took that I knew would sharpen my writing skills. There was even an appellate clerk class. I don't know if it's still offered, but I made sure to take that. So I don't know that the experience has to be exactly in line with what you want to do, as long as you can apply it. So there were some classes I took that they weren't appellate classes, but they were writing classes. So I could take those and say, this doesn't have to do with appeals, but it's still legal writing and that sort of thing. So like I said, I can't give you the best answer because I was very targeted, but that doesn't mean it necessarily has to be.
Gotcha. Jennifer, anything to add?
I don't know if I have that much, and I do come from the other side of this, in that I don't believe that my summer work was so targeted. But I did a wide variety of things. My 1L summer, I split the summer, and I did one half at Legal Aid and then one half with Court of Criminal Appeals Judge Thomas. And then my 2L summer, I was at a torts firm doing plaintiff side work. So I did a little bit of everything. I think at the end of the day, if you can tell an employer and point out how the skills that you already have, both from those experiences and from outside of strictly, your summer associateships, how those apply to your work at the law firm, I think that's how you'll be successful.
That's great. Yeah. What about you, Matt? Anything to add? You're muted, Matt.
I would just add that I need to unmute. Now, I would just say, I guess it always matters where you have your work experience. Obviously, if you worked for Apple or Tesla, that's better than working for GameStop, even though the share price may be pretty competitive right now. But so I would talk to your professors and ask their opinion on that. So whether it's a big firm or a small firm, if you work with someone where you're going to have a good experience, you're going to learn something, and it's going to be applicable to what you want to do next, then I think that's value added. And I think your professors are a great resource in that capacity.
All right, let's we'll go with you for the next student question here, Jennifer. How do you find success when you are litigating or working with counsel outside of your home jurisdiction, like in a smaller county?
I do this a lot because Leitner has offices in Chattanooga, Nashville, and Memphis. So I do a lot of work in Chattanooga and a lot of Nashville work. For the most part, it is similar. That said, I would say larger cities, their bar tends to function a little bit differently. In Chattanooga, not very many lawyers think it's a big deal if you just notice the other party to a hearing. In Knoxville, that is death to your reputation. Never do that. There are just different local unwritten rules about how lawyers practice, but how to deal with opposing counsel. I always try to be as collegial as possible. Obviously, everyone's going to want to zealously represent their client, but at the same time, you don't need to be a jerk to the other side. I try to reach out via phone or email and let somebody know before I'm going to file a motion, and just see if they can get it resolved by agreement. But especially nowadays, now that we're doing Zoom everything and everything is remote, I think it makes a lot less difference than it used to.
Great, yeah. So Matt, I know you've worked kind of all over. I think you may have some good insight here, so we'll go to you next.
Oh yeah, no, I take a lot of cases all over the place. I mean, I think I've had really good experiences with people in large firms in Nashville, and I've had really good experiences with people in Granger County and very rural communities. I'm from a rural community. I think, I mean, the golden rule is still in effect. I mean, I feel like if you treat someone with respect and collegiality and you have that professional courtesy, then that's going to be extended to you. I think if you have a friend that's in that area, then sometimes it's good to reach out to them and kind of get a lay of the land if you have someone that you can refer to. But most of the time, it's whether you're in a big town or a small town, you're all members of the bar, and there's a certain level of professional courtesy that should be extended no matter what the case is or where it is.
Great. What about you, Rameen?
Yeah, the only thing I would add to that is, in my experience, there's no real difference in terms of how you want to approach working with opposing counsel, whether they're here in Knoxville or if they're like, I have a case right now with a company whose GC's in Texas. So I've never met him. I've only talked to him on the phone, but the approach is the same, especially if you're trying to work something out instead of litigate. You know, you want to talk on the phone, you want to keep people involved in your communications, and you're, like they said, you're there to zealously represent your client, but there's no point in starting a fight with the other attorney just because you're on the opposite sides of a case. It's just, it's not productive. Now, you may run into someone who does have that attitude, and at that point, you kind of have to put your defenses up a little bit, but there's never any reason to start off like that, regardless of whether it's, you know, one county over or on the West Coast or whatever. So.
Awesome. Yeah. Okay. So let's get into some more of the questions I had prepared. So let's see, looking back, Rameen, we'll just stick with you. So looking back, is there anything that you regret not doing or planning for while in law school that would have better prepared you for what you're doing now?
I would have taken trial practice had I known where I was going to end up. That just was, litigation was not on my radar at the time. So that would have been helpful to get that experience in on the front end. Working for a law firm would have been good too, just like Jennifer said, with knowing how discovery works and kind of seeing that process a little bit before actually getting involved in it firsthand. Those are probably the two big things, but I can't think of anything that I missed out on so fully that it was to my detriment. Yes.
No regrets, right?
Yeah.
What about you, Jennifer?
Honestly, maybe I think there was some type of advanced torts class, and maybe that would have assisted just because almost all of what I do is civil defense, focusing on tort matters. I did a domestic violence clinic, but because of how that year was set up, we weren't in court all that much, and the courtroom experience I got was great. But I believe UT offers like an advocacy clinic or something like that puts you in court all the time. Something like that gave me more hands-on experience actually in court, may have assisted, but otherwise, you know, I felt pretty good leaving law school.
Great. What about you, Matt?
You know, especially talking about co-panelists this afternoon, I wish I would have worked for a judge or had an opportunity to clerk. I think that would have been an interesting experience and would have given me a better feel for how a trial proceeds and how it goes through the appellate process. But that's probably the only change I would add to anything that's already been said.
Gotcha. So
can I add to that?
Yeah, sure.
If you do work for a judge, typically, and it's kind of the same thing I was talking about with working for a law firm, usually you're given very specific assignments. Take it on yourself if you've got a court record in front of you or whatever, to really kind of look beyond what you've been told to do, to kind of get a feel of how everything fits together if you can. That I wish I had done while I was clerking for the Court of Appeals. That would have made a much bigger difference in my practice than anything I may have missed out on law school.
Awesome. So we'll go back to you, Matt. So what advice would you give to a student to boost their confidence about trial practice?
Go to a trial proceeding. So that's actually, and this is nothing against any members of the bar, but I think whenever I first started, I thought I'm the dumbest person that's ever been given a law license, and I'm the most incompetent attorney. I'm like that bad attorney from my cousin Vinny who has that stuttering problem. I'm going to make a fool out of myself, and I'm so worried. So I think everyone has that, you know, crisis of confidence at some point. But when you go and you read opposing counsel's briefs and motions, and you see problems, we'll say, and issues, and you critique their presentation, you realize that you're just as good as anybody else, and your credentials are the same as theirs. So don't get into that mind game where you're freaking yourself out. I recently read Ron Chernow's biography of Ulysses S. Grant, and Ulysses S. Grant, great general. His first battle, he was terrified. and he engaged with the enemy, and they all ran away. And he said, I realized then that they were as afraid of me as I was of them. And that's kind of true in litigation. Oftentimes you've got some aces up your sleeve that they're afraid of, and vice versa. So don't freak yourself out.
Gotcha. Good stuff. What about you, Rameen?
Preparation is the most important thing. If you do go to a court proceeding, you'll see attorneys who walk in there and they don't have any notes, and they can answer all the judge's questions and tell you everything about every case that comes up, and quote directly from the rules and tell you what the amendments are. I mean, there are people out there that can do that, but typically that is because they have spent however many hundreds or thousands of hours pouring through all that and have 20 years of trial experience, and they've gotten to the point where they can do that. But that's not because they're a natural born litigator that can walk in and do all that. When I go to court, I take a copy of everything I think I might possibly need to look at, every single rule we're talking about, some of the rules I don't think we're going to talk about, sets of briefs. And then when I do walk in, I mean, I'm in front of a judge and I don't know what's going to happen. I don't know what opposing counsel is going to say, but like Matt was saying, but I know that I am just as prepared and as competent at this as anyone else and as I can be, because I've taken the time to get there. So I really think that's the most important thing, is especially if you're doing a trial, you got to know your case backwards and forwards and then backwards again if you're really going to be able to try it. So that's the biggest thing.
What about you, Jennifer? Anything to add?
Not much to add. Those are great responses. Wow. I do think preparation is huge. I remember going to my first deposition and I was so afraid, and it was just a discovery deposition in a premises case, but I knew I was going to do something awful and totally ruin the case somehow. But of course, I had prepared a ridiculous amount, just tons and tons of time, and that made it fine. I was still nervous, still the butterflies, certainly, but it went fine. The other lawyer actually didn't pay attention, which sometimes happens during discovery depositions. I think they figure their client's going to say whatever they're going to say. But for a motion hearing, preparation, bring everything. I usually bring a ridiculous amount of stuff. Sometimes in like a banker's box on a case that's not that complex, but just in case. But I think that, and then also just watching court yourself, it'll help you realize I'm just as educated as these people. I can do this too.
So as Scar said in The Lion King, be prepared. That's the gist of that. Yeah. All right, we got a couple. Let's get some more questions in. So this is kind of, well, Jennifer, we'll just stick with you. So I don't know if any of you will be able to answer this or if all of you will, but we'll give it a try. So did you juggle classes while working as an intern before finishing law school? If so, can you describe that?
I'm sorry, can you repeat that question?
Did you juggle classes while working as an intern? And if so, could you describe that? Yeah.
So I actually did an intern, but my 2L and 3L year, I was a graduate research assistant at UT. I don't recommend that. I worked a lot in non-law things. I was usually working 25 to 30 hours a week, and it made my course load a lot harder. So I don't recommend that. I know my husband, who's also a lawyer, he worked for a gentleman who does solo, mostly criminal defense, white collar criminal defense. I think that was beneficial for him in terms of learning time management, or for me, it certainly was, because it was sort of a sink or swim moment. That said, I don't know that it's so good to overwhelm yourself and make yourself burned out early on in your profession. Time management's fine, but that will come in time once you start practicing. I think that's going to be a personal call for you. Do you like to be super overscheduled and super busy? Sure, go for it. If you like a lot of time to focus on your coursework, maybe just focus on the summers.
What about you, Matt?
Yeah, that's the eternal debate. I think Jennifer offered some really good insights there. I would say I would try to intern or to work for someone who would also be someone that I could reach out to as a mentor and to try to help me get through the law school process. And I think if that's the type of relationship, especially your first year, then I think it would be valuable. I worked through law school, and I was like Jennifer, I worked way too much probably, and it made it harder. But I also understand, I mean, for a lot of people, if you're paying your own way through school, or you have some financial obligations, if you have a family, then you need to do that. You have to do that. So I would try to focus on yourself first, and really know yourself and know what's going to be the best for me, both from an academic and a personal standpoint, and then move in that direction.
That's great. Yeah. What about you, Rameen?
I have the opposite experience. I didn't take a job or an internship or anything other than my school obligations, except for the summers. I had worked for 3 years before I started law school, and my approach was, okay, I'm paying for law school myself, and I've had a full-time job, and this is probably the last time I'm not going to have a full-time job. I'm just going to be in school. So my approach was, I'm going to do well in my coursework, and we're going to focus in on that, but I'm also going to realize this is the last time I'm going to have not as many obligations as probably ever again in my life. So I took advantage of that.
Right. That's great. So we'll stick with you, Rameen, for the next one here. So being in a field that seems so serious and chaotic, do you feel that you have a pretty good work-life balance? And do you have any tips for students who are worried about that aspect of practicing law?
I do. The thing about litigation especially is it kind of comes in waves. So you'll have a month where you've got, opposing counsel in 3 different cases has filed dispositive motions you got to respond to, and you've scheduled depositions, and you get served with discovery you got to respond to. So there may be a 45-day stretch where you are just working nonstop, and you have to work on a Saturday because you've got deadlines and you just don't have time to meet that. And correct me if I'm wrong, but that's kind of a reality of this type of work. But you get through that, and then all of a sudden it's like, okay, I need to write a brief, and I have one motion in a month from now. And so the next month or 45 days or whatever, you don't have as much to do. So it ebbs and flows. It all kind of bounces out in the end, which if you're at a bigger firm, that kind of gets into the billable hours thing, which I won't go into necessarily. But it's kind of what you make of it. If you have the time management and you're a focused worker and you come in at 8, you can leave at 5 for the most part, at least in my experience. If you want to spend 2 hours on Facebook at work every day, then you got to make up for it. Then you're going to be up all night probably. So it's different firms have different demands, and different practice areas have different demands, but it's kind of what you make of it. So.
Great. Yeah. Matt, what about you?
Yeah, that's definitely true. I would just say making sure that you're able to delegate the things that you can delegate, and prioritizing your schedule, and really go through a triage process as far as, okay, what's on fire and requires my immediate attention, and let me get that taken care of. I think the thing that gets people in trouble, at least I'm speaking for myself, if you've got an assignment that is really difficult and it's just hard to get your arms around, then just knock it out early. Just get it done, because when you kick the can down the road and procrastinate, that's what's going to cause you to worry about something and lose sleep at night, and you're going to be working on it at 4:00 in the morning. Mark Twain has a great quote. He's like, when you have to eat a frog, eat it first thing in the morning. So just if you're worried about work-life balance, just embrace the suck sometimes that happens, and it's going to be bad, and just deal with it and go on.
That's great. What about you, Jennifer? Anything to add?
I just want to say Matthew has some of the best quotes. I'm really impressed
That's
with
that
his quote
folksy
game.
wisdom. That's juries like that, Jennifer. So you gotta,
They do.
You have a small town practice. You got to develop those.
Absolutely right. Yeah, I would definitely agree with Rameen in that my practice, especially, it comes in waves. I had 2 months for a while in the fall where it was just like filing like 6 dispositive motions and going depositions, and just working a lot of weekends. But then it'll quiet down, and you'll have a bunch of cases you're settling, and you'll be doing mediations, and you'll be doing things that are quieter. So yeah, just ride out those waves and like Rameen mentioned, if you're doing law firm work, you're probably going to have concerns about billable hours. So when those waves hit, you're going to be billing a bunch, and that's good.
Great. Okay, so we have a time for maybe a couple more here. So a student just submitted this question, so we'll stick with you, Jennifer. As far as juggling court dates, client paperwork, client meetings, etc. goes, do you have any organizational tips for an aspiring trial lawyer?
I'm at a law firm, so I think a lot of folks at a law firm are going to have a very different answer than a solo practitioner because, I have an extensive array of staff and paralegals and legal assistants and secretaries who do a lot of those things and calendar dates for me and things like that. Yeah, I mean, I guess for the most part, I defer to my staff. So ensure that you have somebody that you trust with those types of things. If you are somewhere that you are lucky to have staff that works with you, if you're a solo, I think things are going to be really different. So I think I'll defer to Matt here since he is a smaller firm.
You read my mind, Matt. This is your the small firm guy here. So what about you? What do you have to add to that?
I utilize Clio, and I think any law firm that you're going to go to is going to have some sort of similar practice website. At least to me, it's been invaluable. So whether it's Clio or Practice Panther or something else, that'll make your life a lot easier. So if you go out on your own, I know that it's tough being a small business owner and you have all these expenses, but it's well worth the money. And I think you get a discount on Clio if you're a KBA member. So be sure to join the KBA so you can take full advantage of all the benefits of membership.
I love it when our members do my job for me. So Rameen, you have anything to add?
Find something that works for you. If you like my firm, we just use Outlook to calendar things, and I find that my assistant's really good about adding things to my calendar that come in that if it gets filed or we get a notice from the court. But I also keep a separate list of just things I need to make sure that I'm staying on top of that just stays in front of me until I can cross it off. That usually keeps me honest because then I stare at it and I'm like, I have 30 things, and if I don't get rid of some of them, I'm going to be in trouble and probably lose it. So just find a system that works for you. That system keeps me honest. If you've kind of got a similar method in law school to keep up with everything you need, that's going to expand when you start practicing law. But if it's worked this far, it'll probably keep working in some form. So
great. Okay, so Rameen, we'll stick here with you. And again, this is one that I'm not sure if all of you will be able to answer, but I'm hoping so. It was one that was asked in the criminal law portion last night that I thought may be pertinent here. So I was hoping for some more perspective. So how do you deal with secondhand trauma of litigating cases that may pertain darker circumstances?
I was just thinking, I was trying to think of most of my cases deal with companies fighting with each other, or usually things aren't they're personal, because especially like construction, you have people that think they're building their dream home and then it falls over. That's not to say that no case doesn't matter because people's emotions aren't involved. I think the ugliest case I've ever been involved in am involved in, I should say, is in estate litigation where I have multiple siblings fighting over mom's will and who should be getting the money, and it's ugly. I mean, it's kind of depressing. Not nearly as some of the other things when you get into different areas of law, but you just have to take a step back and say, I've got my client. I'm going to do the best job I can, and I can't take this home. It's got to stay here, whatever happens. So that's the best answer I can give. I don't know that it's a good one, but
no, anything's good. Yeah, I wasn't completely sure if it was pertinent, but Matt, what about you? Anything to add to that?
Yeah, I mean, I've had some cases that are hard. I mean, people are dealing with very difficult circumstances. I think that you can't you can't take your client's burdens on, because you're not going to be as effective in that position. And I think it's a tough balancing act to being empathetic for that person, listening to them, but at the same time, you can't become that person's counselor or best friend. There are people who do need to be that for that person, but you are their lawyer, and that's a unique and very special relationship. So I think having somebody to vent that to and have a sounding board, whether that's your significant other or someone that you can confide in, I think that'll help keep you where you need to be in that professional relationship, and talk to other attorneys about it too.
Great. Jennifer, anything to add?
I don't think I have too much. I think folks who practice a lot of juvenile law would probably have more insight, because they see a lot of really troubling situations. In my practice, I do run into folks who have been injured, and a lot of times I'm deposing them. That's really a learned art as to how to ask people questions about, maybe one of the worst things that's happened to them.
Mhm.
A lot of times they'll cry in the deposition, and you just have to keep in your head that at the end of the day, you're representing your client and you're doing what needs to be done. It's not personal. You can still feel bad for the person and feel bad that they're hurt. But your clients retained you for a purpose, and you've got to advocate for them.
Great. Yeah. So let's not end on a dark note.
Absolutely.
We have time for one more. We'll get one more question here, and we'll get out of here. So this is more practical it's just practical advice. So Jennifer, we'll just stick with you, and then we'll get out of here. So what was the job process like, and when, as a 3L, should I start to send out my resume? Before the bar, after the bar, etc.? Any advice you have towards that?
Oh yeah, I would start early. I would go ahead and start doing it now. I think I was interviewing for my clerkship maybe in January or February 3L year. So I don't think any time except for your first semester 1L year, anytime after that is probably fair game.
That's great. Yeah. What about you, Rameen?
I started sending resumes to judges my 3L year. And the thing about that is there's only so many appellate judges with only so many positions. So you kind of had to track when a new judge was coming on and really kind of be plugged into that network. But in general, I don't know that it's too early. Definitely before the bar, because what will happen is if you wait till after the bar, then they're going to want to know if you passed anyway. So you'll have that lag time between, and then you're probably looking at, the January afterward before anyone starts really considering hiring again. So sooner's better.
Matt, wrap us up, man.
Hustle early, hustle often. So yeah, just get out there and put yourself out there as quickly as possible.
Great. All right. Well, everybody, thank you so much for joining us. We greatly appreciate it. To our speakers, Rameen, Jennifer, and Matt, of course, thank you all so much. I would take down their emails if I were you, and if you have any questions, feel free to pick their brains. At the KBA here, we're also available anytime anybody has questions about anything, wants help with anything, wants us to fix you up with anybody, meet anybody, anything like that. So we're going to be putting these on YouTube, and I'm going to be sending them around. You'll probably get another email about the remaining programs we have later this month. We're going to have these on YouTube as well, but thank you everybody for joining us, and we'll hopefully see you soon.